Welcome back to another episode of Divorce at Altitude. This week, we are talking about work product experts and specifically in the realm of parenting and custody evaluations. We've had a series of recent episodes on parenting evaluations and the state of the public health crisis as described by Dr. McNamara with an episode on with Amy. And this week, we're going to talk with another reputable doctor in this space, Dr. Andrew Loazzo. He is a licensed clinical psychologist in Colorado. He received his doctoral degree from the University of Denver School of Professional Psychology in 1991. Since 1988, Dr. Loazzo has performed over 400 parental responsibilities or custody evaluations and child and family investigations. From 2005 to 2010 with Dr. Les Katz, he led the 40-hour child and family investigator training program. In essence, he trained CFIs. He has testified as an expert witness for the court in many cases, and including some of my own. He's also trained and has knowledge and experience in the area of ethics and standards of care for mental health professionals. He's been providing education and guidance regarding ethical principles in psychology for many years. He's served on a number of ethics boards and committees. I could go on and on. Without further ado, though, let me welcome you, Dr. Loazzo, to the show.
Thank you. It's good to be here.
Yeah. So, and we were talking offline. You had just gotten back from a trip and you are fully booked up. So, we appreciate the time in joining us.
Yeah, glad I can.
So, we're here to talk about work product reviews and work product experts. For listeners that don't know what a work product expert is, can you explain what does that term mean?
Work product expert is someone who reviews the work product of another profession. In other words, their report, typically. In this context, it's either a CFI report or a PRE report. And then that work product expert reviews it in light of a number of criteria, standards of care, whether they fulfilled the court order, whether they answered the relevant questions, whether they applied the right statutory criteria. And I can go into more specific, but then why don't I just go through the process? I think that would be what happens is often is an attorney will call me or send me an email and say, Doc, I got this evaluation. I think it missed the boat. I think it was way off base. The other side has a severe alcohol problem and they didn't even address it. That's an example. So then they typically will send me the evaluation and I will look it over and see if I share their concerns. If I feel there's enough there that is worth producing a work product review, in other words, a written product on my end, they will then send me the underlying data and I will go through it, looking at it from a variety of perspectives and produce a written document that expresses both the strengths of the report, but also the weaknesses. And
Go ahead.
with that, sometimes it can play out in a number of different ways. For example, there have been times when I look at the report and I'm not sure if there's going to be anything there. I look at the underlying data and I think the evaluator got it right. Often I will either write a report that says that, or I'll just give the attorney a call and say, no, this evaluator nailed it. There's a couple things on every eval that I could always point out. But as a general rule, they got most things right. And then the attorney often says, I knew that, but my client isn't hearing it. So I still want you to write a report and tell us why it's a good report. Sometimes I have to do that. But usually in those cases, my appointment ends pretty quickly, or not my appointment, my hiring ends pretty quickly, and I don't go to court to testify.
And Dr. Loazzo, so if you, let's say for listeners that are familiar, they know we had this hypothetical client, Eric Wolf. So if Eric Wolf gets an adverse, let's say it's a CFI, a child and family investigator report, and I come to you and I say, Drew, what are my options here? What can I do for Eric? Walk me through the options that may exist beyond just even the work product review and just how that fits in to the options that Eric has at that point.
First off, the most a CFI and PRE can do is provide recommendations. So nothing's binding. And in that context, there's often a lot of wiggle room to negotiate. So I would often encourage someone to see if you can settle to get closer to what you want that maybe isn't identical to what the PRE CFI said. The other option is if it's a CFI, you can then petition the court for a PRE, and the court most of the time will appoint a PRE in the case. You can, if it's a PRE, you can ask for a supplemental PRE. And then there is also the option of the work product review, where you have the other expert come in and say, Your Honor, these are the concerns with the report, and take that into consideration when you make your ruling. And that's essentially what a work product review does.
And you and I have worked together on these kinds of cases. So there could be a puree that says that Melanie Wolf should be the primary parent, or in the case of let's say there's a relocation, because that's the easiest, because what I describe is there's winners and losers, and it's because usually there's just a real up and down vote on whether the mom or the dad should be the primary parent. So if a puree comes and says Melanie Wolf should be able to relocate with the kids, and then we get a supplemental PRE, and the supplemental PRE would says that Eric should be able to keep the kids as the primary parent, then you come in as the work product expert and do what?
At times, I'm asked to look at both PREs and talk about the pros and cons of both of them. Most frequently, though, I only look at one, and that's the one that attorney's client doesn't like too much.
In that circumstance, the PRE that recommended Melanie Wolf, then Eric would hire you, or I would hire you, and then you would come in and criticize the quality of the evaluation and the work product that was done by that particular PRE.
I would point out the positive aspects, and then, in other words, I would point out what recommendations and conclusions were supported by the data, because I've looked at the data. I would then say, but these are the concerns. Like with relocation, you often find that with some CFIs don't know anything about Spalmer or Chesley. And so they say, it's always best if parents are close together. So I don't think Melanie should move. Melanie should stay here. That's pretty straightforward. I really don't even need to look at the underlying data. I can say they didn't honor Spalmer, which is, of course, to accept that Melanie wants to live where she wants to live. It depends on the nature of the case. It depends whether it's pre-decree, post-decree. Did the CFI follow the court orders? Did CFI do enough investigation? I can go through some of the common complaints that I see or issues I see with these reports, but that would be essentially what Eric would want to do, is to try and bolster that. I recently had a case, I didn't actually go to an example, where the mother had levied false sexual abuse allegations against father that were proven, and in a variety of different circumstances that were proven to be false. She had said that she wished to cut the father out of the child's life, and then she wished to relocate to a country in Europe. And the CFI said, she's been the primary parent, but so she should be able to take the child to Europe. What the CFI didn't sufficiently address was, what does that support? What will happen with father's relationship with the child? And that is something that I would say the court needs to pay attention to this, because maybe, And again, I'm not making recommendations, but maybe the court should consider the lack of support. Maybe the court should consider her verbalization that she doesn't want father in the child's life. Maybe the court should take into consideration that she's already levied false allegations against father. Those things might shift the needle enough that the judge says, well, let me do that. So that's an example.
Yeah, and we recently had Erica Gebhardt as a guest to talk about CFIs, and one of the things we discuss is with attorneys when they have a background and then they pivot or fill a CFI role, they're more apt, it's not guaranteed, but it makes sense, right? That they are gonna be more likely to follow the law, whereas they don't a normal CFI or that's trained a mental health background, they may not have that appreciation for the legal standards. I mean, you've been in the game for so long that you're aware, you know the intricacies of Spalmer versus Cheslick. So, what are the besides just the ignorance of the law, on relocation, Dr. Loazzo, what are the common pitfalls or, errors that you see just as a general observation in looking at all these evaluations?
So there's a whole host of them, and I'll just go through them. One is that they didn't apply the right statutory criteria. Maybe it's a post-decree case and they applied 1410-124 and didn't look at 129. Maybe it's a relocation case and they didn't take into consideration Spalmer. So that's often a very big glaring error. And one of the things I do in my trainings is always recommend that an inexperienced PRE or CFI that's unsure of what case law to be applying or what the statute says, to get clarification of that before you do the assessment. And when someone doesn't, it's a real disservice to the court because the court can't really use it because they've applied the wrong statutory criteria. So that's an example. Another common thing that I've seen recently is that they say something along the lines of, the court recently got rid of domestic violence and spousal abuse from the statutory criteria, so I'm not going to address that. That's not the case. They just bumped it up to the first things you need to be considering. Sometimes CFIs or PREs make that mistake. Sometimes they go beyond the court order. I had a case recently where the evaluator made recommendations for children that were stepchildren that weren't even part of the evaluation. And that was definitely overstepping the lines. I also look for inconsistency between the recommendations and the data itself. But it's always a big red flag when the opening paragraphs say, and the research says joint decision making and 50-50 parenting time, the research says that's in the kid's best interest. So I can almost guarantee, no matter what the data is, he or she is going to recommend a 50-50 plan with joint decision making. In this highly litigated case, that's often the exception, not the rule, because you often have severe pathology or you have high level of conflict. So that's another example. Is there a congruence between the underlying data and the conclusions and the congruency between the conclusions and the recommendations? Again, sometimes they conflate a parent's problem with the other parent. In other words, a parent was really hostile with that parent toward the end of the relationship verbally, and they conflate that with his relationship with the children or her relationship with the children. And that's problematic because what it does is it unfairly colors that parent and blurs the boundaries between his relationship with the ex and his relationship with the children. Another thing that people don't understand is the high threshold for endangerment. I once had a case where a parent grounded a teenager from homecoming because they hadn't fulfilled their responsibilities at home, didn't do their homework, and the evaluator said that was endangering the child. And therefore, it was a risk, and the the primary parent should be moved to the other parent. And that's not the threshold for endangerment. Maybe it was inappropriate, maybe it was too harsh, but that's not endangerment. So that's an example. What you often find, not only do you find that kind of tendency toward 50-50 and joint decision making, you find it aspirational. You say, these parents should be able to get along. I think if they both got some therapy, they would be able to communicate a lot better. They do these aspirational recommendations that aren't consistent with the data and aren't necessarily reflective of the reality of how they actually do communicate. You look for all kinds of confirmation bias. You also look for that. Often, one of the fascinating things about doing this work for 30 years is that when you first meet a parent, you hear their story and you say, oh my goodness, this will be an easy case. I've got it figured out. Yeah, the other side must be a real jerk to do what he or she's done. And then all it takes is 2 days later, when you interview the other parent, you realize, oh, there's another side to the story. If you close yourself off to not being open to different hypotheses and you close yourself off and you jump to conclusions, you're going to miss the boat and not really take into consideration which hypothesis is more robust and standing. Sometimes I have CFI and PRE reports where they just do broad recommendations without specifics. The parents should split the time equally and try and make decisions together. And that's parents need a lot more and they're expecting a lot more. They're expecting a specific parenting plan. And when you recommend joint decision making, you have to be recommending alternative ways of resolving the issues. And often PREs and CFIs don't do that. They sometimes you see recommendations that are just overboard and too long standing. They don't give parents an opportunity to do the improvements they need to do. You can have a parent that comes in and says, hey, I messed up. I wasn't as good a parent as I had, and I've been reading these books. I've been taking these courses. I want to do better. And sometimes you can provide, okay, they're going to have supervised visitation for the first month, and then they're going to have therapeutic intervention, and you can provide a path out for them to be the kind of parent they want to be. And when PREs and CFIs don't do that, they can often just really, that's when parents get really upset with PREs and CFIs, when they don't feel their options are limited and they don't have any way out.
Yeah, and Dr. Loazzo, for anyone listening, they hear a lot of these catchphrases, and it is you can go really deep on this. And if anyone listening wants more information, there's episode 23 and episode 50 where John Zervopoulos, who he's a doctor or psychologist and a lawyer, we unpack some of the confirmation bias and these other things that you referenced. But just I'm curious how just and obviously there's a sample set or there's some bias in terms of the reports that you get because someone's upset
Right.
about them. So, how, in terms of how frequently do you think inadequate or problematic reports are submitted? Just from a
Yeah,
general
that's a
principle.
good question. First off, it's important to note how hard it is to get the experienced evaluators. Kate McNamara talked about that in her episode. And it really is. I got over 180 requests last year for PRE evaluations, and I do 8 a year. And that's just not about me. That's about the whole system. There just aren't enough good people doing the work these days. I think what that leaves is people often don't get the quality evaluators or CFIs that they'd like to get, and they get less than. And from my own experience, I'm doing 3 to 4 work product reviews a month. It is a concerning situation in how troublesome the evaluations are that are coming out.
Has that been we'll strike that, we'll edit that out, but uh, do you think that there has been strike that out. Let me ask this a different way. Have you seen a market or material increase in the frequency of inadequate reports that has been correlated? Correlation is not causation, but with this issue that Kate McNamara, and for anyone listening, that's episode 91. But have you seen an increase recently in inadequate or problematic reports?
Yes, I have. I've seen it's been a steady increase, especially over the last 5 years. I've been doing work product reviews for probably 12 to 15 years now, and I have never had so many calls for work product reviews as just this past year. And when I look at them, and when I look at them, I find them far more inadequate than what I would have seen 10 years ago.
What would you say, Dr. Loazzo? I don't think Dr. or Kate McNamara was asked this, but what would you say to the person that says, "You guys have been in this game for a really long time, and it's like everyone thinks the Rolling Stones were the greatest band and that today's music is just rubbish, and that you guys have been in this for a long time, and you were just looking down on a younger generation." I guess, what would you say to that?
No, they're what Kate referred to was the important piece of this, which is that to do this work well, you have to have an expertise in a lot of different areas. And not only that, to do it really well, you've got to have a number of years of experience. So when people don't have the expertise, it's not an age thing, but when they don't have the expertise and they don't have the years of experience, that often leads to the inadequate evaluations. When I've done when I've done 400 evaluations, I can pull from those 400 evaluations in terms of recommendations and craft 8 pages of detailed when transitions should happen and when they shouldn't. I've learned from experience about recommendations that didn't go so well, so I'm not going to do that again. When the old guard is getting out of the business, I don't know how the new guard is going to sharpen their game.
It's a fair point, and I it's been interesting. I've had conversations. There's a number of experienced divorce lawyers that I have worked with that are considering retiring or have given me their kind of game plan. And there's a new generation, certainly, of divorce lawyers. But I think about my own career where people used to ask me, "Do you have kids?" And I would chafe, and I was a young, arrogant lawyer, and someone could say that I'm still a young, arrogant lawyer. I would be like, "Why
Right.
does that matter?" But what you say is agree with is that I have seen the transitions. I've gotten the calls about Christmas Eve, and because the parenting plan was not specific, and then you see what people are unfortunately capable of interpreting words, or rather bringing various issues, whether it be narcissistic personality disorders or substance abuse. And just over time, you really understand those dynamics. So, with that in mind, what value do you bring as a work product expert to a case? If there is, especially there's an increased likelihood that there's going to be a problematic report, what value can you add as a work product expert to, let's say, Eric Wolf?
So the value I add really is up to the judges to decide. In other words, judges will often welcome my input because I'm trying to be fair and balanced. I can say the POE did this well, but these are the concerns the court needs to pay attention to. And with a WPR and with an expert who can opine on, that's a lot easier than trying to do it through cross-examination of the POE themselves. And so I can spell out what the concerns are. I can even do a hypothetical. In a typical case, this is what my parenting recommendations would look like. I'm not applying it to this case. I'm not saying you should apply it to this case. This is not a recommendation, but this is what a quality kind of parenting plan would look like if you wanted to do a 50-50 of relationship. I will often do that. And judges have typically expressed appreciation for my role in the case. Because another thing that I would hope CFIs and PREs appreciate is that they can take this critical feedback and they can say on the stand, oh, I really should have talked to the kid's therapist, or I did underestimate his, but rarely do I get that. Usually they double down and they get defensive. And that is something I wish I could change in the community. That I like it when people do work product reviews on my PREs because they can sharpen my evaluative skills. That's what I want. And I don't have a dog in the fight per se. So when CFIs and PREs double down on the recommendations, even though they've applied the wrong statutory criteria and it doesn't make sense and it's not congruent with the data, that just does a disservice to the whole process.
Yeah, my observation is that experts, whether it be business valuation experts or parenting experts, when they and the most reputable, the kind of best in class, they are often the ones that will admit when they do something wrong and they will say, you know what, I hadn't considered that.
Right.
But it gives them even more credibility as opposed to just being defensive. But you referenced something earlier that I wanna highlight for listeners, and that is the kind of role of you as a work product expert making recommendations. So, can you tell our listeners a little bit more about that dynamic? Can you give recommendations on a specific case? And if not, what can you do and why can't you give recommendations?
There's a variety of reasons you can't give recommendations. First one is that I haven't this applies to therapists, by the way. This applies to not only to anyone who's not in a court-appointed role as a CFI or POE making recommendations, taking parenting time or a decision-making recommendation. So the principles behind why you can't do it is number one, you don't have enough direct assessment to make a recommendation. I haven't met these people. I haven't observed them. I haven't interacted with them. I haven't given them an opportunity to challenge my perceptions and for them to defend themselves. There's not a sufficient basis for me to make recommendations. Secondly, the court has consistently frowned on, and so has the Department of Regulatory Agencies, frowned on anybody who's not in that court appointed role making recommendations because it's below the standard of care. And the standard of care that really covers the waterfront is 1243-222, and that's prohibited activities. And it's broad enough that it goes toward this issue. Has acted or failed to act in a manner that does not meet the generally accepted standards of professional discipline under which such person practices. Those are the reasons that I don't make recommendations. Now, I can say the PRE should have considered this option. I can say this is what a parenting plan would look like in a typical situation. I can say here are some options for the court to consider around substance abuse monitoring that the CFI didn't consider. I can do all of those things and give the court more understanding about what would be a more appropriate recommendation, but I can't make the recommendation itself.
And I think I wanna make sure that people picked up on that because I can tell you as a practicing lawyer, I get it all the time where Eric Wolf comes into my office and says, "My therapist says that Melanie should not have the kids and
Right.
I should go for full custody," or that their Melanie is a narcissist and there'll be some sort of diagnosis, or that I am a great parent and you neither you as a work product expert nor Eric Wolf's therapist is in Colorado is, and you can correct me if I'm wrong, is allowed to make that recommendation because Eric Wolf's therapist has not treated Melanie. She has not seen Eric
That's
purportedly
right.
to, or presumably parent or Melanie. And that is segues into, which I think is one of the most important roles as a work product expert, or maybe to augment your role as a work product expert in terms of instructional or a standard of care reviews. For people that don't know what that is, and you have been so helpful in some of my cases about relocation and really having ideas about how should they transition at an airport, because you've seen the different issues that have arisen, so you can bring these ideas and really guide the court on what are the issues that the court or the parties really should be thinking about. So can you maybe talk about a little bit about the instructional expert and then the standard of care review?
Yes. So different than a work product review where I'm looking at a particular report and saying the pros and cons of that. A standard of care review is actually looking at a professional's behavior and have they performed in a manner that is consistent with the generally accepted practices. And for example, if a therapist has submitted an affidavit that says mom is a narcissist and shouldn't have any parenting time, yet that therapist is not in a position to do, that's below the standard of care. So I will often be hired to do a standard of care assessment about another professional's behavior. So that's what standard of care review is. And that's what the Department of Regulatory agencies are concerned about. They're going to come down hard if you are performing below the standard of care. An informational one is Dr. Loazzo, this is a new judge. I don't think they understand very much about alienation. Can you present a 3-page document that kind of summarizes the highlights of alienation and the research, and then come and testify about what the judge maybe should be paying attention to in this case? So that's an example. It can be on a number of things: child development, suggested parenting plans for young children, overnights for infants, all kinds of different, kind of very specific educational information that I can provide the court.
Yeah, and then as a former DA, we used to do this where the inter-partner violence or the cycle of violence, we would have an expert in a criminal case for domestic violence. And because the jury, most people are, we don't have jury trials in a court, but there might be a judge, and we'll know that the background of the judge, or we should know. Hey, they were a county attorney, or they were in civil litigation, or they were a real estate attorney. They may not know what enmeshment is. And
Right.
so we'll bring you in and you can talk about what enmeshment is and put that in maybe the context of a work product review where you can comment on the PRE did not really investigate the issues of enmeshment.
That's right. Work product reviews will often have informational, educational components to it.
And so Dr. Loazzo, what's the best time to hire a work product review? So Eric Wolf comes in to my office and there's a relocation. Is it immediately when we find a CFI or a PRE, or do we wait until we get that poor report or the strong report? Really, it doesn't, I don't think in my experience it matters because we want to know the strengths, we want to know the weaknesses. And so we'll consult with you, but when's the best time to do that?
The best time to do it is after the report is released, after the CFI or POV report is out. I can anticipate with some evaluators and CFIs that there's going to be problems. Sometimes they'll say, if they contact me mid-case, the CFI is refusing to meet with me anymore and she's completely thrown me under the bus. I can't do much with that. I have to have the actual written report to know what to do with. So I'm called after the written report is submitted. Sometimes attorneys are conflicted. Do we want to wait another 6 months and try and get a supplemental or go for a PRE? Or do we want to keep the court date and have the work product review? That's a very strategic decision. It's not something that I can weigh in on, but sometimes it does make more sense to let's get a thorough eval done and revisit the issue. And if that's another poorly done one, then Dr. Loazzo can do two WPRs, but hopefully not. But other times it does make sense. The court isn't going to grant the extra evaluation, and the court does not want to move the court date. So you've got 2 weeks to get us something. That's when a work product review can be helpful.
Yeah, for listeners that may not understand that if Eric Wolf, for example, is in a relocation and he doesn't want Melanie and the children to leave, then he's gonna he's incentivized to drag it out. So he's gonna be more inclined to get a supplemental PRE in that context. But if it's the other way around, there's certainly going to be an analysis for Melanie where I just want to go to court, and no one wants to go to court, but there are certainly cases and relocation cases, just generally, those are the cases that are litigated and go to trial oftentimes, and where really come in from a work product standpoint. But once we hire you, Dr. Loazzo, what are the steps that you took? You said you get a call, you look at the report, you talked about data and the file. So for those
So
that,
I want to hear what the attorney and the client's concerns are. I'm going to form my own opinions, of course, but I want them to express what they feel is problematic with the report. So I will get that from the attorneys. I will 9 out of 10 times I look at the underlying data. Sometimes it's not enough time. Sometimes it's not enough money. Sometimes the PRE or CFI report is just so off base in terms of you can see it right there that I don't need to look at the underlying data. But usually it's a lot of time going through all of the underlying data, the evaluator's notes, the submissions, the psych testing, all of those things, and then preparing the WPR. Usually it takes me between 3 to 5 weeks to do it from start to finish. It tends to be a pretty intensive process, and it's a real shame. It's a real shame I'm needed at all, frankly, especially when they can't afford a PRE, so they get a CFI. They get a CFI that does a poor report, and then they have to hire me to do a work product review that's often more expensive than the CFI report itself. And that's not fair to anybody.
yeah, Dr. Loazzo, you're very similar. I often will tell people, they'll ask me, "What kind of lawyer are you?" And I'll say, "I'm the lawyer that you never want to call, and you're the expert that no one wants to call." Because it means not only are they going through a divorce, but they've gone through some sort of parenting evaluation, and they are concerned enough either because it's such a poorly done report. And you also, I think it's worth mentioning is that oftentimes you will be hired to support an evaluation that is favorable to the client and bolster.
That's yes, that's happened. That happens a few times of it, but honestly, Ryan, that probably is 1 out of 20 times.
And it often is because there's something wrong,
Right,
and it's someone's going through a divorce, they have to call me, and then something even worse happens, and that is that they get an adverse recommendation or report.
right.
It is an unfortunate circumstance, but you're like the fourth branch of the government in the sense of like the media, which they say in terms of the transparency and the supervision of the government. Like you're holding other professionals accountable. I think a lot of people could take these recent episodes to feel skeptical or depressed or pessimistic. And I think that there's certainly some validity to that feeling about the state of affairs with parenting evaluations. We're seeing a lot of conflict just as a general in our
Right.
society and with COVID, whatever the case may be. But it's helpful to know that there's at least some options to do something about it.
Yeah, and judges really appreciate it because they know too when they've gotten a good eval or not a good eval. And so they want to What are my other options? What are the things that CFI or PRE should have considered? And then they can make the decision from the bench about what makes the most sense for the family. So I think work product reviews play an important role, often can play an important role when there's gaps in the CFI or PRE report.
Dr. Loazzo, I really appreciate the time. I know that our listeners, if they've gotten this far, have appreciated the insight that you have provided. For we'll have links to the show notes to your bio and your contact information for those that don't know where to find you. Can you tell us what's the best way to reach out to you if they want to learn more about work product review or some sort of instructional expert or something within your, or they want to fit within those one of those 8 PREs that you take on
Right.
a year?
The best way to get in touch with me, and also the best way to find out about the services I offer, is to go to my website, which is www.drloazzo.com. And in that, I have all the forms to download. I have a description of the different services I provide. I even have a schedule about my availability for PREs. So that is really a very comprehensive, I keep that updated. So that's a very comprehensive overview of my current state of practice. And there's also a way that they can contact me and send me an email through that website. So
Well,
that's the best.
I'll make an observation. You've been experienced, but the other thing is that you've been willing to come on something like podcast. But for those that can't see the video quality, we'll have portions of this. But you, as a testifying expert, I commend you for really putting in the effort to having kind of quality audio and visual because that really does make a difference. I know that in a trial that we've had, the ability to see and hear you clearly compared to the other experts. And one of the observations I've had on some of the more experienced PREs is that they really struggle with technology and being able to understand text messages and Facebook and the experienced people that you mentioned are that there's a dearth of them. Even then, there's some limitations because
Right.
we're doing this remotely right now, and a lot of your experts are they're testifying remotely because of the cost concerns, and I think that's really important for people to understand the thought that you have put into not only just your education, but also the presentation that you bring with you, which is one of the reasons you're the go-to for work product reviews.
Yeah. Thank you, Ryan.
Thanks again, and we'll have show notes, but Dr. Loazzo, until next time, thank you for joining us on Divorce at Altitude.
I've enjoyed it. Thank you.